next one to speak is Victor Fenwich, which is a partner in Istanbul. He's a very experienced casualty handler. He's very well known to the Italian market. You should also speak a little bit of Italian this time.
A long time ago.
Yeah, a long time ago. He used to speak Italian, then changed his mind. I think it was better to speak English. He's delivering a speech on quite famous cases, which is the old LW bunker bankruptcy, which trained drove a lot of mitigation out of it. It was a famous old trader which collapsed. I'm not sure the reason why, but I think Victor will be answering this. Okay?
I will try. Good afternoon, ladies and gentlemen. You may see that I put my jacket back on. That's not because I've got cold. It's just that these types of videos seem to end up on the internet. And I wouldn't want my mother to see me about a dress or underdress.
But it depends where it goes on the internet. The internet is very big.
Thank you very much. I suspect that most people in the room know something about the OW bunker saga. That is the collapse of the OW bunkering group of companies based in Denmark and the consequent problems that ship owners have had and are continuing to experience around the world. There has been much written in the press about it, and I saw a quote in Lloyd's List which suggested that the amount of litigation that had come out of the insolvency of OW was the most spectacular legal shipping imbroglio so far of this century. So of course as lawyers we're absolutely delighted with the way things have worked out so far. Others of a more technical nature have estimated that the losses that are up for grabs and may be suffered by the physical suppliers of the bunkers could amount to almost $1 billion. So serious money, and therefore that explains why a serious amount of attention has been given to the dispute. So what I'm going to do in the short period of time that I have is just take you through the position under English law, with particular reference to a recent test case that has gone through the English courts called the res cogitans, and then we'll compare that with the position in some other jurisdictions and see how it looks and how it shapes up. Bear with us. Perfect. We'll set the background first. OW bunkers were one of the world's biggest suppliers of bunkers. They claim to have supplied about 7% of the world fleet. During the year 2014, they stumbled into financial difficulty with the end result that on the 6th of November 2014, they applied for restructuring in the Danish courts, and that ultimately has led to insolvency. The way OW bunkers worked was that sometimes they were the physical supplier of the bunkers, but very often they were the contractual provider of the bunkers. It's a little bit too close to the in my mouth for a minute. That is the issue which has given rise to all the problems, because there is a contractual liability that the owners may have to OW, or in fact their assignees in the insolvency, which is a bank called ING. Is there a liability owed by the owners to ING? And then, or as well, is there a liability owed to the company that actually provided the bunkers, the physical suppliers? There are proceedings in various jurisdictions around the world, and as I mentioned at the start, what we're going to look at now is the test case which has gone through the English courts, which involves a ship called the Rescotans. It's progressed very quickly through the procedure because it was agreed amongst the parties that that was what they wanted. They wanted some sort of guidance which can go out to the wider market so that others can learn from the result. So you can see that although OW Bunkers only went into insolvency in November 2014, by April of 2015 we already had an arbitration. 3 months later the commercial court gave their view on the case. 3 months after that the Court of Appeal did the same, and then 7 months later we had the Supreme Court, which is the highest court in England and Wales, pass its decision. To understand the case, I've prepared a slide which shows you the factual matrix or the factual background of the contractual position. Let's hope that this is clear. What happened was that the owners of the ship contracted with a OW subsidiary in Malta, OW Malta, to provide bunkers for the ship. They in turn went to their parent company, OW Bunker and Trading, in Denmark, and they arranged and entered into another contract for the supply of the bunkers with an independent company called Rosneft. In fact, it wasn't Rosneft who supplied the bunkers, it was one of their subsidiaries called RM Bunker Limited. So that's the factual position. What had happened at the time of the insolvency of OW was that the bunkers had been supplied. The bunkers had not been paid for by the owners, but Rosneft had paid RM Bunkering. And of course, when OW Bunkers went into insolvency, Rosneft became concerned, and they contacted the owners and demanded payment. So the owners had 2 claims coming at them, one from ING as the assignees of OW for payment under the contract, and one from Rosneft for payment as the physical supplier of the bunkers. What to do? So what they did was they commenced an arbitration, because arbitration was provided for in the contract with ING, or with the OW, and they sought a declaration that they were not obliged to pay the price for the bunkers to ING. And the reason that they said that was they believed that, they argued that because OW had not paid Rosneft for the bunkers in the first place, then relying on the Sale of Goods Act under English law, property could not be passed by OW to the owners, and therefore there was no obligation on the owners to pay the price for the goods. And we'll just spend a little bit of time expanding on that. The Sale of Goods Act is a piece of English legislation, so it applies in this particular case because English law applied to the contract. And a contract for sale of goods, which is what the owners argued this bunker contract was, is defined under Section 2, and it says that a contract for the sale of goods is one where the seller transfers or agrees to transfer the property in the goods to the buyer, and in return he gets the price of the money, so fairly straightforward. There's an implied term also in contract of goods sales, and that's Section 12 of the Act, and the implied term is that it's held on the part of the seller that in the case of sale he actually has a right to sell the goods, and in the case of an agreement to sell he will have the right at the time that the property is due to pass. So in essence the owner's case was, well, they did not have, OW did not have title to pass because they had not paid for the goods to Rosneft. And as title did not pass, there is no remedy available under the Sale of Goods Act to OW to claim the price from the vessel owners. And the background to that, the owners said, is look at section 49. That, they said, provided an exhaustive regime within which a seller can seek a recovery from the buyer in cases where they haven't been paid the price. So section 49 says, well, where property passes, then you can sue for the price if the buyer hasn't given it to you, or alternatively, if property hasn't passed, you can still sue for the price if the price is payable on a day certain, irrespective of delivery. And in this case, owners said, well, the first opportunity fails because actually the property never passed because you never paid for it, the title couldn't pass. And the second option for OW to succeed in making recovery also failed because under the contract for delivery there was a credit period within the terms which allowed the owners to burn the bunkers. So actually the bunkers had disappeared by the time and be used up by the time that the price would have become payable. So indeed, that option failed as well. So the court thought, well, that's all very well. Let's have a look at the two contracts themselves and see whether we believe that they fall within the ambit of the sale of goods legislation. So they looked firstly at the contract between OW and Rosneft. And they identified that there are a couple of interesting clauses. One is that there was a credit period of 30 days for OW to pay Rosneft. And the second one was that there was a retention of title clause in that contract. And that retention of title clause allowed the buyer and ultimately indeed the vessel, if they got hold of the marine fuel within the 30 days, to hold them as bailey on behalf of the seller, but they could commingle the fuel with other fuel on board the vessel. So that was one of the things that was anticipated in that contract. In the other contract, which is the contract between OW and the owner, they identified a longer payment term. There was a 60-day credit period there. And again, a retention of title clause, so no property could pass from OW to the owner until full payment. However, there was a license to use clause, and the license to use clause allowed the buyer, in fact, to burn the bunkers as long as he was using them to propel his vessel, which of course he was. So he was contractually entitled to destroy the bunkers effectively before he paid for them. So what did the court think about that? Well, they thought that this was a fairly unique type of contractual arrangement. I mean, I say that it's unique, it's not unique in the bunkering world, but they felt it lay outside the scope and remit of the Sale of Goods Act, and therefore they decided that the protection that is afforded to a buyer under the Sale of Goods Act does not apply in this particular case. So that meant that the owner's defence or request that they had a declaration that they were not liable to pay OW under the contract failed. Because OW was entitled to sue on the contract for the debt that was owed to them. The only term which the courts sought to imply into the contractual situation or the contractual relationship was an implied promise that OW had acquired the right to authorise the use of the bunkers before payment. And they did go so far even to say that even if the Sale of Goods Act had applied, which they said didn't, then they felt that the setup under Section 49 of the Act, which the owners had said described an exhaustive procedure for remedies that were available to the owners was in fact not exhausted at all, and there was a possible way around that in any event. So in a way it was bad news for the owners, and they clearly have an issue as far as paying IMG now as a result of that Supreme Court decision. But looking at it more broadly, there has been some discussion in the press and the media about whether there are wider implications as a result of this decision, and perhaps it is possible to imagine beyond the bunkering world that there are contracts out there where property is destroyed, credit terms are granted, payment is delayed, which actually might fall within the scope of this decision, and where parties were previously contracting thinking that they had the protection afforded under the Sale of Goods Act, they may now find that that no longer exists for them. Of course, there remains the possibility that the physical suppliers of the bunkers will also bring a claim. We now know that IMG, on behalf of OW, or on behalf of themselves as assignees of OW, are entitled to payment, but the physical suppliers will also be looking carefully at what their options are. So there is a risk of double jeopardy to the owners. Perhaps they may have to pay twice, who knows. One potential upside for IMG as well is that, of course, they will receive the full price of the cost of the supply of the bunkers. Previously, if they had been trading normally, and this has been just a bog standard regular trade, the bulk of the money would have been passed to the physical supplier. OW would have kept only the commission or the margin. But in this case, in the insolvency, it is possible that they may be able to keep all of the money, which is good news for the creditors of OW. And it's also important to say that the Reciprocitans case turns to a certain extent on its own facts. And again, you may have seen certain commentary in the press suggesting that each case has to be assessed individually, and that's absolutely true. These contractual terms, although perhaps common, will vary from contract to contract, and it is important to dive down into the detail of a contract to try and work out what the precise obligations and liabilities are each time. So it's there for guidance purposes, but there may be a way of distinguishing it if you need to. Excuse me. So very briefly, excuse me. Very briefly, I thought it might be worth just trying to compare the position now in the English law against the position in some other jurisdictions. And I thought we would just briefly look at the USA, Canada and Singapore. Firstly, in the USA, the position in the USA on behalf of the owners is not too bad, as I understand it. They have a system over there which allows and provides for what's called interpleader relief. And that is a system. What's happened is that the owners have received claims from OW or IMG, and they have received claims from the physical suppliers, and they have gone to the court and said, look, these are competing claims for the same amount of money arising out of the same set of circumstances. Please allow me to put up security or put money into court, i.e. the price of the goods, the money that is owed, and you, Mr. Court, sort out who recovers what. And the American courts have accepted that there is subject matter jurisdiction in relation to this particular type of interpleader action, and they have agreed that the owners can do that. So that's good news for the owners, because one of the side effects of that is that the court issues an injunction preventing the both OW and the physical suppliers from taking any other action directly against the vessels in the US. The other good news for the owners in the US, as I understand it, is that there have been a couple of decisions that have come out recently, the Costco Haifa case and the Son, forgive me if I've mispronounced that, where it has been decided that the physical supplier does not have a maritime lien against the vessel for the provision of the bunkers. Because the contract for the provision of the bunkers was placed through OW, rather than through the owner directly or through an authorised agent of the owners, it does not satisfy the criteria under American law, so I understand, to establish that a maritime lien exists against the ship. So again, that is good news for the owners in the US. In Canada, on the Campotex case, it has been decided that through, again, an interpleader type arrangement, the court decided, and perhaps quite sensibly, some might say, that the money should be divided between IMG and the physical supplier. So the price for the goods would be split as follows. The physical supplier receives the price that he charged OW to provide the fuel, and OW just get to keep the commission that they would have earned had the contract gone through normally. To do otherwise, the court said, would have been unconscionable, and indeed it seems quite a sensible result. And finally, perhaps in Singapore, you can see that the owners there also tried to establish these interpleader proceedings. There they were unsuccessful. The court said, as far as they're concerned, interpleader doesn't apply. They say that the basis for the claims between brought by the physical supplier are different to the claims which are brought by IMG. The amounts being sought are marginally different. And there are a number of other reasons as to why they felt that interpleader was not available for the owners in Singapore. The good news for the owners in Singapore is that the physical suppliers have failed, in a case called Precious Shipping, to succeed and persuade the court there that they were entitled to recover damages for conversion of the bunkers by the owners. So there they said, look, we gave you the bunkers, you burned them, you've converted them, you owe us damages for that. And the court said, well, that's ridiculous, really. You knew that we were going to use them, the terms of the contract were such that we could burn them, and therefore your claim fails. So that really is a fairly quick canter through the position under English law, and again, comparing that with the position that exists in some other jurisdictions. There are, of course, many more jurisdictions where you might get a slightly different result, and we'll probably enjoy reading about that over the forthcoming months and perhaps years to come. I hope it has been of some interest to you. Perhaps you've learned something from it. Thank you very much for listening.
I was amazed by the fact that it took just 1 year for degrees. I mean, in Italy it takes 2 years for a judge just to realize that the case was started. Yeah. Okay.